Hello everyone, I'm Advocate Zenia Nagpal, a legal associate in NRI Legal Services. In this session, I would like to talk about a very general query that we keep getting and a situation we face more often than not while the suit is pending in the court of law. Now, what happens when a party in the suit, be it a plaintiff or a defendant, dies while the case is still going on in the court? Here, it becomes pertinent to first look into the matter and analyze whether the right to sue survives. Right to sue means right to seek relief. Right to sue survives when the cause of action survives or continues even when the party in the suit had died. It means that if such right does not survive upon the death of a person, then the matter ends then and there, and the suit will be abated, that is, dismissed. Let us consider the effect of the death of the parties during the pendency of suit. In case of plaintiff's death, the plaintiff in the suit is a person who brings the legal action against one or more defendants. What would happen if a person who's seeking the legal remedy from the court of law were to die himself? Let us examine this one by one in three different circumstances. First condition, when the sole plaintiff in the suit dies. In such cases, the suit doesn't necessarily have to be abated. In fact, it can be continued by the heirs or the legal representative of the deceased person, given that right to sue survives. Now, second condition, when one of the several plaintiffs dies, wherein the right to sue survives. In this case, the court will make the entry regarding the effect of the death of the plaintiff and proceed in the suit with rest of the plaintiff. The last condition, when one of the several plaintiff dies but the right to sue does not survive. In such conditions, the court, upon the application from the legal representative of the deceased plaintiff, will make the said legal representative a party to the suit and proceed in the case. Now, in the situations where the plaintiff or plaintiffs were to die after the hearing in the matter has been concluded and the case is now listed for the pronouncement of final judgment, or say where the hearing has been concluded and the court has passed a preliminary decree but is yet to pronounce a final judgment. In either case, the suit will not be abated. It is because by this time, the matter of rights of the parties have already been adjudicated upon and have been examined by the court. Therefore, regardless of the death of the plaintiff in the suit, the court may pass the judgment as if the said plaintiff was still alive. Now, in case of defendant's death, the defendant in the case is a person against whom the suit is instituted and the relief is being sought. In cases where the only defendant in the suit dies upon the condition that the right to sue is still surviving, the suit can be continued against the heirs or the legal representative of the deceased person. The heirs or the legal representative can be made party to the suit even in the cases where one of the several defendants had died, given that the remedy can still be sought against the existing defendants. In such cases, the legal representative or the heirs are impleaded in the ongoing suit after they submit the application regarding the same and informing the court about the death of the defendant. This application by the legal representative should be made within the prescribed limitation period of 90 days. If no such application is made, the suit against the said deceased person will stand abated. In the situations where the plaintiff is unaware of the death of the defendant and for this reason is unable to submit an application for bringing on record the legal heirs of the deceased defendant, he may take the plea of ignorance of death within the further statutory period of 60 days. In this case, the learned court will scrutinize whether there was a sufficient ground for not making an application within the total statutory period of 150 days. Now in case of both the plaintiff or the defendant, where either party fails to inform the court regarding the death of the party in the question within the prescribed limitation period, one can move an application with this regard under Section 5 of Limitation Act, requesting the court for the condonation of delay by giving the appropriate reasonings. Furthermore, it is important to mention here that the legal representative or the legal heirs of the deceased are impleaded as a party to the suit only when the rights of action and the demands can be sought against them. Therefore, in the matter of personal actions where the relief can only be sought against the deceased, the suit will stand abated. A legal maxim, that is, action personalis moritur cum persona, applies, and it means that the personal action dies with the person. Apt example for the said personal actions would be suit for damages for assault, for malicious prosecution, for defamation, or for the breach of contract, or for the dissolution of marriage, and so on. Furthermore, as a general rule, it is the obligation of the pleader of the deceased party to inform the court regarding the death of the person. Regardless of this duty, the contract between the pleader and the party shall subsist through the deceased party's legal heir. That being said, a suit can never be instituted against the dead person. Such a suit is called non-heir and shall have no legal effect. However, if such suit is filed without any prior knowledge, then an application can be filed by the plaintiffs to bring on record the legal heirs of the deceased. And if the learned court is satisfied, it shall breathe the life into the suit by impleading the legal heirs of the deceased defendant. So friends, if you found this video informative and productive, please don't forget to like and share. In case of any query, you can drop a comment below or can write us to query@nrilegalservices.com. Thank you.